you all. Thank you all for coming. My name is Nina Beth Carden, and I'm the director of the Maryland Campaign for Environmental Human Rights. On behalf of Claire Miller, our communications director, and myself, we welcome you to this webinar on the impact of state environmental rights amendments and other statewide environmental justice laws. We are delighted to again be working with the University of Maryland Environmental Law Clinic. It's wonderful director, Seema Kakade, and her students. And this year we're working with Johanna Adashek, Michael Rada, and George Rice. And they have been wonderful partners working on this research project with us. We are excited to be working with them and even more excited to be learning from them this morning what they have found. So with that, Johanna, I will turn this over to you.
Thank you very much. We are so happy to be here, and thank you everyone for coming. Today we will be presenting on recent environmental justice laws and state environmental constitutional amendments. Next slide, please. Thank you. My name is Johanna Adashek, and these are my colleagues, George Rice and Michael Rada. We all work at the Environmental Law Clinic at the University of Maryland Carey School of Law. At the Environmental Law Clinic, we provide support for different organizations in various ways, and we are here for a purely educational purpose. We also understand that many of you have a lot of knowledge about amendments and legislation, so we have tailored this webinar in recognition of that. However, I will try my best to explain some of the legal concepts in recognition of our diverse audience. We will also save the last 15 minutes for Q&A, and please feel free to post your questions in the chat while we move along. In my first half of the presentation, I will focus on the judicial interpretation that courts have brought with environmental rights amendments. An environmental rights amendment, or an ERA, is an amendment to a state constitution giving the people a right to a healthful environment. The new amendment that MDEHR is pushing through has the acronym EHR for Environmental Human Rights Amendment. But the ERAs of the past differ in whether they are a substantive right, or if they are a policy declaration, or if they are inside the Bill of Rights or outside. As you can see in the pink, 16 states have policy declarations. They say something like, "It shall be the policy of this state to conserve and protect its lands and waters for the benefit of all of its citizens." Some designate funds, and others require their legislatures to enact laws. However, none of them guarantee a right. 6 states, as can be seen in the purple or green, have substantive rights. They say something like, "Each person has the right to a healthful environment." Next slide, please. Today I'll be delving into 3 states, Pennsylvania, Illinois, and Hawaii. I chose these states because they have differences that allow for different judicial interpretations. They all guarantee a right to a clean or healthful environment. However, Pennsylvania's ERA is the only one that is located in the Bill of Rights of the 3. Illinois and Hawaii's stipulate legal enforcement of their right against any party, public or private, while Pennsylvania's does not. And Pennsylvania has a trusteeship provision that the other 2 do not have. I'm going to start with Illinois. Illinois' amendment has 2 sections. The first one is a policy declaration, like we saw in the pink above, and the second is its substantive right. It says that each person has the right to a healthful environment. Each person may enforce this right against any party, governmental or private, through appropriate legal proceedings, subject to reasonable limitation and regulation as the General Assembly may provide by law. Healthful in this context was found by the court to describe the environment in terms of its direct effects on human life. So it does not pertain to animals or nature or the sort. We will, in the next slide, be reviewing case law. Much of Illinois' environmental rights amendment is about standing. Standing is immensely important because without it, a court will not entertain a case. This can be seen in Pioneer Processing, Inc. in the 3rd row. In this case, the Illinois Environmental Protection Agency approved a hazardous waste permit. However, right after that, the municipality rescinded their approval, and the Attorney General brought a case contesting the permit, and the Intermediate Appellate Court held that the Attorney General did not have standing to bring the case. This is really important because if the Attorney General doesn't have standing to bring a case, who can bring a case? However, the Supreme Court of Illinois held that the Attorney General does have standing and used the ERA to show that the public has an interest in a healthful environment that was raised to a constitutional level. In the City of Elgin v. County of Cook in the fourth row, the court again addressed standing and held that while the ERA helps overcome standing and overcomes this special injury requirement that common law has in Illinois pertaining to environmental cases, it does not create a cognizable cause of action. Maryland common law similarly has a special injury requirement that plaintiffs need to overcome when bringing environmental lawsuits. This makes it really hard for plaintiffs to bring environmental cases. Glisson v. Marion in the last row takes this a step further and holds that the ERA confers standing to a plaintiff even if their injury is one that is common to the public. This is really important, especially in Maryland, because even with the Maryland Environmental Standing Act, plaintiffs still need to demonstrate a particularized injury, one that is not common to the public. So an ERA could be very helpful for overcoming standing in environmental cases. Next, we are going to review Pennsylvania. Pennsylvania's ERA starts with the people have a right to clean air, pure water, and to the preservation of the natural, scenic, historic, and aesthetic values of the environment. The right mentioned here was interpreted by the court to act as a limitation on the state's power to act contrary to this right, and any regulation is subordinate to the enjoyment of this right. Thus, laws of the Commonwealth that unreasonably impair it are unconstitutional. In the second clause, Pennsylvania's public natural resources are the common property of all the people, including generations yet to come. As trustee of these resources, the Commonwealth shall conserve and maintain them for the benefit of all people. Commonwealth here actually refers to state and local governments and all three branches of government. This is really important in one of the next cases. Next slide, please. Thank you. In the third row, in Commonwealth v. Parker White Metal Co., an employee was criminally charged for dumping hazardous waste 9 times, violating the Solid Waste Management Act. The court, as co-equal branch of government, considered themselves also a trustee of Pennsylvania's natural resources, no less than the executive and legislative branches, and it was also their duty to conserve and protect resources. It also helped that the explicit purpose of the act was actually to implement the ERA. In Payne v. Kassab, the Supreme Court of Pennsylvania addressed standing, like we saw in Illinois, and again held that while the ERA helps to overcome standing, it does not create a private right to relief. Lastly, in the first row, we went backwards up this time, in Commonwealth v. Harmer Coal Co., the court again used the ERA to show the public interest in the protection of the environment. This was a really big win for Pennsylvania because it was a few years after the enactment of the amendment, and it actually required a mine owner to fully drain an adjacent mine that they didn't own before their permit could be approved. In fact, 1/3 of all the cases in Pennsylvania Supreme Court mentioning the Environmental Rights Amendment were purely for the purpose of illustrating the public's right to a healthful environment. In the next few set of cases, I'm going to overview a bit of self-execution. Pennsylvania has a long history with self-execution, as many of you likely know, so I will do a very brief overview. This is just an example of what could happen with judicial interpretation of an ERA and not what needs to happen or might happen, as Illinois didn't even need to discuss self-execution at all. However, it is really good to be prepared for what can come. A few years after the enactment of the amendment in Commonwealth v. National Gettysburg Battlefield Tower, a company had federal permission to build a 300-foot observation tower in the middle of the Gettysburg battlefield. The Attorney General brought suit under the amendment. However, the Supreme Court of Pennsylvania, in a plurality opinion, held that the ERA was not effective on its own and needed supplemental legislation to work, meaning that it was not self-executing. In Robinson Township, 40 years later, a similar plurality of the Supreme Court held that the ERA actually was self-executing. And in a footnote, they noted that in the Gettysburg case, since it was a plurality of the case, the opinion would actually revert to the Intermediate Appellate Court, where the Commonwealth had held that the amendment was self-executing. However, finally, in Pennsylvania's Environmental Defense Foundation in the third row, the court reaffirmed in a majority opinion that Pennsylvania's amendment is self-executing, getting rid of any confusion that may have existed for about 50 years. Lastly, we're going to overview Hawaii. Hawaii's amendment reads that each person has the right to a clean and healthful environment as defined by laws relating to environmental quality, including control of pollution and conservation, protection, and enhancement of natural resources. Any person may enforce this right against any party, public or private, through appropriate legal proceedings, subject to reasonable limitations and regulations as provided by law. This last provision does not suggest that the legislative action is needed before the right can be implemented. Although it appears to preserve the ability of the legislature to impose reasonable limitations on the exercise of the right exists and can be exercised in the absence of such limitations. The Supreme Court of Hawaii even held the last provision as a catch-all to include all previous environmental regulation, else the amendment itself may be unconstitutional as restricting the right to enforce environmental quality laws, as is required in the first clause. The Environmental Rights Amendment in Hawaii was first promulgated in 1978. It was then used in 1981 in a footnote in Life of the Land v. Land Use Commission. It was then rarely used in any appellate case until 1996 or 7. Recognizing the amendment's lack of use, the legislature promulgated an act that allowed private citizens to overcome the financial barrier to entry by obtaining attorney's fees in certain circumstances. Proponents thought that private enforcement would complement government enforcement rather than be supplanted by it. In the third row, in County of Hawaii v. Alalu Homeowners, which is a very important case interpreting the amendment in Hawaii, the court explains that the ERA not only conveyed standing, but it also created a private right cause of action to enforce laws relating to environmental quality. Taking this a step further, in the three cases that are held in the last row, the amendment was held to convey a property interest protected by the Due Process Clause. This was seen in the latest three cases entertained by the Supreme Court of Hawaii, which allowed environmental groups to intervene in administrative proceedings discussing power purchase agreements for coal plants and natural gas lines, and even forced the administrative body to consider greenhouse gases produced outside their state when considering new power purchase agreements. Throughout all this research, I have seen three very important points. And the first is that state environmental amendments function best with and bolster supplemental legislation, like we saw in Pennsylvania with the Solid Waste Management Act, and how it really helps plaintiffs bringing a case under a law when they can point to an environmental rights amendment that says that they have a constitutional right to a healthful environment. Second, ERAs help confer standing. They do not, however, create an independent cause of action, meaning you still need other legislation. Third, there is no concern for an influx of litigation as seen in Illinois and Hawaii even had to promulgate an act to promote more people bringing cases under the ERA. Lastly, I just want to touch on environmental justice in this last slide of mine. And I would like to recognize that I saw very few cases relating to environmental justice utilizing ERAs. However, I believe this could be because that environmental justice legislation is so new, or that people have yet to try under ERAs. But for whatever reason, it is really important to also have coexisting legislation, which is the main goal of many groups. And on this point, I would like to pass this over to my colleague, George Rice.
Okay, so first of all, I want to thank everyone for tuning in today. I'm hoping that you all are learning a lot and that this webinar can provide some value to you all. We can move to the next slide, please. So Joe just talked about state constitutional environmental rights amendments, but I'm here to talk about the role of state statutes that might correspond with a constitutional environmental rights amendment and are more targeted to include environmental justice concerns. So I'm going to discuss the recently passed New York and New Jersey environmental justice statutes, which have been getting a lot of attention, and I want to provide my thoughts on their relative strengths and weaknesses. Next slide, please. So starting out, we want to figure out, how does New York define environmental justice? So New York's Article 48 is the recently passed environmental justice statute. And under Article 48, environmental justice is defined as meaning the fair treatment and meaningful involvement of all people, regardless of race, color, religion, national origin, or income, with respect to the development, implementation, and enforcement of laws, regulations, and policies affecting the quality of the environment. And fair treatment under the statute means that no group of people, including a racial, ethnic, or socioeconomic group, should be disproportionately exposed to pollution or bear a disproportionate share of the negative environmental consequences. So starting out in this top left row structure, we're gonna examine the structure of Article 48. And it has a relatively simple structure. It creates the Permanent Environmental Justice Advisory Group. The article also creates responsibilities for state agencies, and it establishes the Environmental Justice Interagency Coordinating Council. Moving to the significant provisions that tell us how the statute works. Essentially, Article 48, it creates the Environmental Justice Advisory Group, and that advisory group is tasked with creating a model environmental justice policy that applies to state agencies, and that model environmental justice policy is created in consultation with representatives from minority and low-income communities, regulated parties, and the public, as well as the Environmental Justice Interagency Coordinating Council. So under Article 48, state agencies that engage in activities or operations that have a significant effect on the environment must also create their own individual environmental justice policies. And those policies are supposed to guide the agency in its decision-making process in terms of taking agency actions or performing operations. Finally, you have the role of the Environmental Justice Coordinating Council. They basically coordinate the activities of agencies that are required to adopt environmental justice policies, and basically just provide information to state agencies and the public. In terms of the benefits of Article 48, from what I've gathered, the statute's beneficial because it at least gathers input from low-income and minority groups as to what a model environmental justice policy should look like. It also requires state agencies to adopt their own environmental justice policies, which means that environmental justice concerns will be a consideration throughout state agency decision-making process. However, from my understanding of Article 48, there are some significant downfalls as well. And one of the biggest ones is that the Environmental Justice Advisory Group really doesn't have much authority. So they can make the model environmental justice policy, but that model policy itself doesn't have any force of law. Essentially, the model environmental justice policy is a recommendation for state agencies. Additionally, while state agencies are required to adopt their own environmental justice policies, there's no requirement in the statute that state agencies craft their individual policies off the model policy put forth by the Environmental Justice Advisory Group. Ultimately, the agencies are never required to adhere to the environmental justice policy, and there's nothing in the statute speaking to what a state agency's environmental justice policy must contain. So my overall assessment of the statute is that it's largely procedural in nature. It doesn't actually grant any substantive rights. In other words, it seems like all the agencies have to do is check the boxes saying, we have an environmental justice policy. We considered it when we took our actions, and then they're good to go. So switching gears here to New Jersey on the next slide, please. New Jersey's Title 11 is their environmental justice statute, and it's different than New York, which was more of a procedural statute. Here, New Jersey's law actually has some substantive provisions with it. And so just getting down to the structure here, Title 11 has a narrower scope than the New York law in that it doesn't create a broad procedure for state agencies, but rather targets the polluting facilities and environmental justice communities themselves. The statute directs the New Jersey Department of Environmental Protections to identify overburdened communities and consider the cumulative impacts on the communities. And it also creates substantive permitting requirements. Under the effects of the significant provisions columns, you can see that one of the biggest effects of the statute is that it puts permitting obligations on polluting facilities. And the way it does this is it first requires New Jersey Department of Environmental Protections to identify overburdened communities, which are defined under the statute as any census block group in which at least 35% of the residents identify as low-income households, at least 40% of the residents identify as minority or as members of a state-recognized tribal community, or at least 40% of the households have limited English proficiency. The statute also requires permit applicants to prepare an environmental justice impact statement that considers the adverse environmental impacts on the overburdened communities identified by the department. The applicant is also required to hold public hearings in the overburdened community. And finally, the department is required to deny permits upon a finding that they will cause or contribute to adverse, cumulative environmental or public health stressors in the overburdened community. For existing facilities that wish to expand or renew permits, the department can condition the permit concerning the construction and operation of the facility to protect the public health. And I will add that where the department determines a new facility will serve a compelling public interest in the community where it's to be located, the department can also grant a condition based on the construction and operation of the facility to protect public health. In terms of the benefits of New Jersey's Title 11, from how I'm reading the statute, one of the benefits of Title 11 is that it targets the polluter rather than merely placing procedural requirements on state agencies. Ultimately, under Title 11, in order for a facility to renew or get permits, they're required to create an environmental justice impact statement. There must be a finding of no adverse environmental impacts by the New Jersey Department of Environmental Protections. And this provides the statute with actual teeth. It gets the regulated community on board to reaching environmental justice goals. Title 11 also uses relatively objective criteria to determine who falls in an overburdened community. which I think provides some clarity. It's not an over vague category that could end up being either too broad or too narrow. And also by placing actual substantive requirements on permitting facilities. Title 11 is different than a lot of other environmental justice statutes. It's not just the policy statement that, we care about minority and low income communities. No, this is a piece of legislation that actually makes some positive changes by requiring permit and establishing permitting requirements. Some of the downfalls of Title 11 is that state agencies are not required to consider environmental justice issues unless they're seeking a permit to operate a facility in an overburdened community. As compared to New York, where almost all state agencies have to adopt an environmental justice policy to guide decision-making, here the New Jersey statute doesn't place any environmental justice requirements on agencies other than the New Jersey Department of Environmental Protections or agencies seeking a permit in an overburdened community. In addition, Title 11 doesn't have any input from environmental justice communities. While it might be beneficial in some regards to have an objective criteria to determine overburdened communities, the New Jersey law insulates all decision-making processes from the public or environmental justice communities. So if there's room for improvement, it would be to include a system of public input or dialogue between the regulators, the regulated, and environmental justice communities. So moving to the last slide here. In conclusion, we want to take a look at environmental justice in Maryland. So in 2001, Maryland created the Commission on Environmental Justice and Sustainable Communities. And I'm sure you guys are all aware of that. Advocates have claimed that the commission has really failed to influence any meaningful policies, partly because of its lack of sufficient representation from affected communities of color. And the commission has also been criticized as being largely reactive in nature rather than proactive. In terms of cumulative impacts bills in Maryland, Maryland Department of Environment has set up they'll be hosting a working group to review how cumulative impact assessments could be incorporated into the MDE permitting process in a way that's legal and feasible while addressing environmental justice. And in 2020, House Bill 1206 was an attempt at a cumulative impacts bill. It was the Clean Energy and Energy Efficiency Investment in Disadvantaged Communities. The purpose was to require the Department of Environment to, in consultation with the Commission on Environmental Justice and Sustainable Communities, to designate certain communities as disadvantaged communities by examining, among other things, the cumulative impacts on those communities. Then the commission was supposed to develop policies and recommendations to place the highest priority in terms of spending on clean energy and energy programs in disadvantaged communities. This bill did not make it past first reading, and it's potentially just as a result of COVID because it was up in February 2020. And then in terms of the Maryland Environmental Policy Act, House Bill 689 in February 2020 was also an attempt to basically revise the Maryland Environmental Policy Act and make it more consistent with the National Environmental Policy Act. That also made it to first reading, but it appears because the legislature convened as a result of COVID, it will have to get reintroduced. So there's a lot of work to be done right now. This is an area of law that's been changing a lot. And there have been several attempts to get Maryland to get bills with an environmental justice component passed. In closing, environmental justice legislation can provide excellent protections for disadvantaged communities. In addition, constitutional environmental rights guarantee by way of supermajority and the voters of this state that environmental rights stay in place as houses of the legislature change. The most effective environmental justice policy approach would be to adopt a constitutional right to a clean environment and enact coinciding environmental justice legislation as additional support. Thank you all. I think we're going to move to questions and answers now.
Thank you all. That was fabulous. And yes, I imagine that everyone on here, because they heard about this through the Maryland Campaign for Environmental Human Rights, understands that we are in fact promoting an environmental human rights amendment for our state constitution, which would be in our Declaration of Rights, putting that right on par with all of our other civil rights. We do have a Senate sponsor this year, Senator O.B. Patterson, and a House sponsor, Delegate Monica Fisher. So for the first time in the 3 years or so that this bill has been put in, we now have bills in both houses simultaneously, and they're identical bills, which is fabulous. And that's obviously one of the reasons that we wanted the University of Maryland Environmental Law Clinic to help us understand how we can anticipate this bill being implemented, this amendment being implemented if it does pass, and how we best structure, and there's a question later on which we'll get to, how we best structure that corollary legislation that can help make an amendment as robust as possible. So let's go back up to the chat and start seeing some of the questions. As a non-lawyer, I have a fundamental question, which is, what does private right to relief mean? Joe, did you want to answer that one?
I would love to. Before a case can be brought in court, it has to pass two initial barriers. The first is standing, which we discussed. Standing in the federal courts refer to redressability, injury, causation. In states, they're a little bit different, or they can adopt federal regulations. However, beyond standing, you also need a cause of action. And cause of action just means that there was a law that said that you as a citizen could sue someone for something they did, usually a non-discretionary duty of the government or a violation of, let's say in Pennsylvania, the Solid Waste Management Act. If somebody's illegally dumping waste, then you have a cause of action to bring a lawsuit. Did that answer your question?
And so the right, a private right to relief means that because I have a cause of action, I can get relief from the offense of that action? That's the corollary?
You can overcome the initial barrier to court. It doesn't automatically mean you'll win, but it means that you will get to be heard in court.
Okay, I want to come back to that in a minute, but let's go to some other questions as well. Is the New York EJ Advisory Group composed of volunteers, or are members paid? And does it have paid staff or any budget?
So it is, I believe it's volunteers that comprise the advisory group, and it's members of organizations that represent minority and low income communities. And so I imagine there might be some sort of staff budget or compensation scheme for their time and effort, but they're not paid. So it's not like a full-time job or anything like that. I hope that answers the question.
Yeah, and I think it also has impacts on our own commission on environmental justice and sustainability and how we're functioning, because as everyone knows, ours, I think you were mentioning here, George, that our commission has been under attack recently for not being as robust as it can be, for not filling the seats properly, not being proactive enough. And so one of the questions that we would have obviously is, who's on the commission? How well is it staffed? It is staffed here by MDE, by Maryland Department of the Environment, and how much capacity does it have to work and to make recommendations? So Joanne, thank you for that question. Claire Miller asks, New York is also in the process of pursuing passage of an environmental rights amendment. As we understand it, they might be passing it this year. It's their second legislature that's going to be looking at it. Once that amendment is passed, how could it work in concert with the environmental justice statute?
So that's a really good question. I guess it would sort of depend on what is in that environmental rights amendment before you could fully give an answer on how it would interact with the environmental justice statute, especially with New York's, just the way that New York's statute sort of just, it creates obligations on state agencies. So it might, an environmental rights amendment might somehow increase your capability to have standing, but you'd sort of have to see specifically what's in that amendment. And then New York's is kind of just because of the procedural nature and the fact that it only creates obligations on state agencies. It's sort of uncertain on how it would interact with a environmental rights amendment at this moment.
And one of the things that you are showing us is that in some measure, the language of the amendment is really, it's up for grabs. It's almost, you cannot fully rely upon it until the courts define it. And as you were showing us, Joe, there's no doubt, it seems to me, in anyone's mind, that the Pennsylvania Amendment should have been self-executing from the very beginning. And yet the courts didn't really see it that way until 40 years later or so. And so one of the things that we would have to do here in Maryland is to try to be very, very careful as we develop that legislative history with our amendment to explain exactly how we anticipate this amendment being interpreted, which doesn't guarantee that the courts will interpret it that way, but at least it gives us a head start. So yeah, so George, I think that you're right. It really does depend on the language and how it's interpreted, and how the state legislature then passes more laws to enforce it. So I had a question. How often does New Jersey need to review the demographics to ascertain who is or what is an EJ community? Do they indicate that in any of their information?
I believe it was once every 2 years, if I'm not mistaken. So I'll have to go back into the statute and do a little bit of digging. I'm hoping that the links that I posted on the slide, they go to the statute on Westlaw, and I'm hoping that everybody can have access to kind of poke around and look at the specifics of it, because I was really trying to highlight the big ticket items in that statute. But from my recollection, I believe they have to once every 2 years at least go back, take a look, and see who falls in that overburdened community category.
And another question, which you might not be able to answer at all, but one of the things that we're hearing is that there's a sensitivity that environmental justice communities might not really want to be labeled as such. They don't want to be seen as communities that are lacking in assets, of lesser economic value to live there. Right? There's a sensitivity to identifying environmental justice communities on the one hand. At the same time, we need to identify them so that we can have proper remedies and provide the resources that we need to them. Have you come across that in any of your readings?
So I was actually just talking about this to a colleague, Michael Sammartino, and it is interesting that you bring that up, because New York's law is entitled environmental justice, and New Jersey's is entitled overburdened communities. So I think right now there is a conscious effort by some of these state legislatures to try and take away from some of that stigma and still address the problems that those communities are facing. And so I think you're going to see because right now environmental justice is sort of a burgeoning area of law. Everybody is getting excited about it. And I think as states across the country start enacting their own environmental justice legislation, you might see people start moving away from the phrase environmental justice and into some more politically correct terms, overburdened communities and things of that nature.
Which I think simply seems to stress the fact that we need to engage in all of these discussions from the very start, the people who are the impacted communities, because they will guide us in the best way to move forward. So thank you. Our Lawrence Adashek says, with the question for language with a suggestion for language for a Maryland constitutional amendment state, one, that the Environmental Rights Amendment is a fundamental right, two, be self-actualizing, and three, include a private right of action. And if Pennsylvania shows that a constitutional environmental rights amendment works best with with additional legislative acts, what would those best be in Maryland? So let me answer the first half, and then I can turn it over to Joe to answer the second half. The current suggestions for the language for the Maryland Constitution, which of course we're calling the Environmental Human Rights Amendment, so that we can make sure that people understand that taking care of the environment is the best way one can take care of humanity and populations, because you can't have a healthy population if you don't have a healthy environment. So our Environmental Human Rights Amendment states that, yes, each person has a fundamental and inalienable right to a healthful environment. Those are the words that we're putting into the language, that each person has a fundamental and inalienable right to a healthful environment. It will be self-actualizing. Does it include a private right of action? Since I'm not sure I totally understood what that meant, I will put that back to Joe to answer. And then Joe, you want to talk about the second side of that, is that Pennsylvania, if the Pennsylvania shows that a constitutional environmental rights amendment works best with additional legislative acts, which we totally endorse, what would you suggest those additional legislative acts be? And then maybe we can have someone from the participants who are probably involved in additional legislative acts suggest what they're up to. So Joe, you start.
So, sorry if I didn't explain this very well earlier. A private right of action is just if you, a private citizen, can bring a lawsuit. And a way that it seems that courts kind of address this is they really keep saying, especially in order to kind of curb an influx of litigation worry, they keep saying that amendment like ERAs do not create a private right of action. You do still need this other legislation, like we are hopefully going to see in conjunction with the Environmental Human Rights Amendment coming up soon in this legislative season. Any additional legislative acts would be great with an EHR. In the cases I read, which are quite a few, there were always other legislation, and the amendment really works to bolster this legislation, to say, not only is there already legislation here, but the people have a constitutional right to a healthful environment. So this act is even more important. And in that way, they work really well together, because the EHR, the Environmental Human Rights Amendment, will just give a little bit of extra oomph to supplemental legislation.
All right, great. And some of the other supplemental legislation that we've got, there's a bunch out there. Cumulative impact statement is cumulative impact issues is one of them. Issues of CAFOs, issues of bringing climate into consideration when the Public Service Commission, for example, considers roads or other infrastructure that's being created. Whenever we consider transportation and with federal funds, and we have to do environmental impact statements, climate would have to be taken into consideration. Water, there's some wonderful water bills, the coal plants. I mean, there are all these other ancillary bills that are now being brought. The environmental community is, in a sense, afire with environmental justice legislation that it's bringing forward. So we have a robust cluster of bills that we're looking at. And I'm sure there's several people on this call who are in fact in the front lines of those bills. So Lawrence, thank you for that question. Veronica says, in Maryland, the challenge is holding the state agencies accountable for their actions or inactions. And Veronica, thank you for saying that too. It's not just what people do, it's what they fail to do. Who are the state agencies like MDA, MDH, MDE, et cetera, accountable to, especially when their action or inaction cause harm or injury to public health and the environment? Veronica, are you talking about In Maryland, you're talking about in the New York and New Jersey issues, examples?
Actually, I was talking about it in reference to the Environmental Human Rights Amendment that we are submitting. And also, is there any way we can, one, who is accountable in Maryland? And how can we ensure that the amendment holds them accountable in the future?
Well, again, I mean, not being a lawyer, I will attempt to answer. I don't know if there are any lawyers on the call who want to answer after me. The amendment is structured so that individuals can hold the state, and which means all the state agencies, all the state entities. It's kind of, we're seeing the word state as Pennsylvania saw the word Commonwealth, which is what Joe was talking about. It's the state and sort of all the sub government of the state and agencies, commissions, anything else of the state. So they are all liable. Our amendment does not allow us to sue a private entity, but we hold the public entities, the state and subdivisions of the state, responsible. So that's what our amendment would do. Does that answer your question, Veronica?
Yes, because as Brian Frosch spoke yesterday at the Public Health Association meeting, and he said even the Attorney General's office can only point out where the agencies are not following the law, but they can not compel them to follow the laws or
That is
take
why
action.
the amendment, exactly. Yeah, Joe.
I actually saw a really good example of this in Hawaii in the last 3 cases I talked about, because the government was purchasing power from coal plants and from natural gas lines, and they didn't really have a duty to not do that, right? They have discretionary duty to choose where their own power comes from. However, the Environmental Rights Amendment actually allowed these private citizen groups, these environmental coalitions, to intervene in administrative proceedings and actually have a meaningful time to speak and have their opinions heard. And then I guess after that, if they wanted to bring a lawsuit coming after that, judicial review is especially pertinent after administrative review. So I think there's a good chance that people will be able to hold public entities accountable.
ESLC staff, I think that's Eastern Shore Land Conservancy. I'm not quite sure if that's right. If that's wrong, type it in the chat. Tell me, wait, you're someone else. Saying, do you know of any efforts from nonprofits that have been able to leverage community support to pass this type of legislation? You can please, unmute yourself and let us know. Are you talking about Maryland again, or New Jersey, or New York? Did they leave? Are you on mute? Okay, I don't know. Well, let's assume that they're talking about New Jersey and New York for a minute. Do either of you know how these laws got passed in those states? Who was behind it?
So I didn't do a whole lot of focus on my research in the legislative history behind it and how it got passed, because I feel like almost that could be a webinar in and of itself, that whole topic. So I wish I had come prepared to speak to that, and it's a really great question. So I'm not sure how nonprofits worked to sort of leverage that type of legislation, but I imagine there was input along the way, and I know there was probably some sort of commenting period that went down. I'm happy to take a look into it and follow up with Rabbi Cardin and provide answers for you that way. And I hope that helps.
Okay, and ESLC staff, if you want to respond in any way in the chat, because I'm sorry you're having your mic problems, you can please do. Veronica, again, aren't we just creating new overburdened EJ communities if permits that are detrimental to public health and the environment are allowed in areas currently not classified as an overburdened community? Shouldn't we provide protections to all communities so that we reduce the number that become overburdened? So Veronica, you're absolutely right. And I think that is why the amendment is not exclusively about overburdened or environmental justice communities. The amendment says each person has a fundamental and inalienable right to a healthful environment. So the idea is not to move from one sacrifice zone to another sacrifice zone. The idea is to make sure that we do not have sacrifice zones, that we begin to build a society where we have progress and development without the concomitant degradation that's been coming with it. So that's the whole idea. The fact, though, that it does say each person and gives each person a right gives extra standing and extra clout to those communities that have environmental justice violations, put upon them. And it will hopefully bolster, as Joe's been saying, the amendment itself is not going to be able to do the job without legislation, but it will bolster the ability of creating legislation that requires remediation for those historic environmentally degraded, overburdened communities. So we have to be proactive in responding to the overburdened communities, but we're not saying don't also protect those not yet overburdened and not polluted communities. So I hope that answers that question.
That was a terrific answer. Thank you.
Thank you. And SEMA recommends something to think about for all of us, how to coordinate on all environmental legislation going to Annapolis in 2021, especially in educating delegates who might be hearing testimony on multiple environmental bills. So SEMA, you have hit the nail on the head. One of the things that the environmental advocacy community is, I think, just beginning to explore really is how do we come together and provide sort of a collective presentation of bills, education about these bills, because too often, a session will say, we're going to pass one so they don't do it formally, but sort of informally, we're going to pass one, maybe two environmental bills and sort of focus on that. And the other environmental bills have to stand in line and wait, any number of years before they even get an appropriate hearing. And I think the environmental, this is now Nina Carden speaking, not for anybody else, but my sense is that the environmental advocacy community really is getting tired of having us be seen as siloed in our bills and being pitted one against the other and fighting for SEMA. And if I can say one more thing in the last minute or two, that is why the Maryland campaign says my internet connection is unstable. I hope it's not too much unstable. That is why the Maryland Campaign for Environmental Human Rights was created, to create this amendment that can provide a solid underpinning of all of our other environmental efforts and environmental laws and regulations. Cannot be threatened in any way and would have to be enhanced, as a matter of fact. So the more that we can have this sort of this I don't know what to call it, even this sort of embrace of all these environmental initiatives supported by this one fundamental right, the more we think we can help people understand that this is all of a piece. All of a piece, all the granular bills are all of a piece, and we have to move forward with as many as possible to get to the ultimate goal that we all are seeking, which is environmental health for everyone. So I thank you for that question. All right, folks, it is now 11:58. We would have to sign off in 2 minutes. It sounds like a very good moment to end. Let me just turn to our wonderful presenters, Joe and George, and I don't know, Michael, if you want to say anything, any last words for us?
I just want to say thank you guys for tuning in and showing your support for environmental justice and an environmental rights amendment. And I think if we work together, hopefully we can get something passed that really makes an impact. So thank you guys.
And thank you. And you said that you would help, we could share your slides and the presentation. So that would be wonderful for those who don't have good enough eyesight to read everything as fast as you put it up there, because you have wonderful information for us. SEMA, thank you so much for working with us. This is just terrific. We will send out more information to follow up with this. So you can, again, have the slides and have the recording. And we hope in December to have a webinar with our bill sponsors so that you can speak with them and hear their excitement about the Environmental Human Rights Amendment. And we will continue to be in touch with all of you. And please be in touch with us. Thanks so much, everybody. Take care.
Wonderful. Thank you.